In a black community, it is often said that blacks can't be racist because black lack political power. While it is true that blacks as a collective are not in a majority and therefore don't have any political power to oppress whites, it is also true that most whites don't yield any real political power. A white person who is poor or middle class is nearly as oppressed as the average black person. They just don't realize it because they naively think that the system represents their interests. As John Jacques Rousseau so eloquently explained, most people are looking down instead of looking up. What this means is that they're looking down to see who they are able to oppress instead of looking up to fight against their own oppressors. People don't mind being oppressed so long as they are not at the very bottom. The system of white supremacy was created in order to prevent black slaves and white indentured servants from joining forces and dismantling this entire capitalistic system, which serves to oppress us all. Systemic racism doesn't exist under anarchy. Systemic racism can only exist under statism/capitalism, which allows a racial majority to form a faction for the purpose of disenfranchising those who are in a minority. When a racial majority uses the coercive power of the state to give themselves an economic advantage, that is the true definition of systemic racism. All races are both statists and capitalists. I am very careful about using the term racism or white supremacy correctly. Simply calling someone the N-word or hurting their feelings is not true white supremacy. It's only when a racial majority aligns itself with the state to give themselves economic or political advantages that you get true systemic racism. White men have created occupational licenses for the sole purpose of giving themselves economic advantages while creating barriers to entry in order to eliminate competition from people of color. This is the true face of white supremacy.
Washington State is ditching the bar exam requirement to practice law. Usually, if you're a lawyer, usually you would go to law, you take the LSAT, then based on your LSAT score, you get into law school. Then you'd take your law school exams and papers and things, and then really all of that was just the appetizer. That's the
Okay, so this is Matthew Knowles from the Daily Wire. And the reason that he's saying usually you take the LSAT, usually you take exams while you're in law school is because this person has never attended a law school. Uh, First of all, let's go through his background, right? Because he's speaking with such authority. Look at the way he's waving his hands as if he's so knowledgeable about what goes on with attorneys and bar admissions. This guy knows absolutely nothing. Okay, so this is Matthew Knowles. He's a political commentator from the Daily Wire. He was born in Bedford Hills, New York, descended from Italian, Sicilian, and Irish immigrants. So this isn't a settler, right? This is a Johnny come lately migrant who basically came, I guess his maybe his grandparents came to America and now he thinks he has standing to disenfranchise people who were here far longer than his family. Um, yeah, this is a problem. This is the reason why we should have closed borders. Because if you're going to come here to make a better life for yourself, fine, but you don't get to align yourself with the state and then disenfranchise people who were here before you. So he's Catholic, which that's fine. A lot of people are saying that he's a theocrat. But I want to look at his career and look at his education. He was an actor, right? Um, Before going to the Daily Wire, he was an actor. He played where was the part about him playing a gay character? Matthew Knowles appeared in the student film House of Shades in 2012. He appeared as a queer man that seduced another man at a nightclub. Now he's totally homophobic, doesn't support same-sex marriage. He's all traditional. He's Catholic, and at the same time, he's a capitalist, which is a complete oxymoron. You can't be a Christian and also be a capitalist. It would be easier for a camel to go through an eye of a needle than it would be for a wealthy person to get to heaven. So you got your priorities all mixed up when your master is all about money and you clearly worship the government. You're a hardcore statist. And then let's look into his education, right? He has a bachelor's degree from Yale University. Now, I understand that Yale is prestigious, right? But at the end of the day, this is a bachelor's degree. He doesn't have any graduate education. He's never attended a law school. He doesn't know anything about the admissions process for bars, for state bar admission. So this person is not an authority on law licenses. He doesn't know anything. But because I hate to say this, but because he's white, he thinks that he can put on a monkey suit, sit here with a straight face, and he's the authority on all things. He's even more of an authority than a black person such as myself, who has actually graduated from a law school. Now, when I first listened to this diatribe, I assumed that he was an attorney, right? I didn't know anything about Matthew Knowles. I came to his channel because of his commentary about bar exams, right? Then I realized, oh, this guy is actually a well-known YouTuber from the Daily Wire, but I had never heard of him. So suffice it to say, this person is not an authority on law licenses. I am. I have researched this issue thoroughly. I know the whole history. And his video was very short, right? He had to use a lot of fillers. He started talking about abortion, and it was a little commercial. He doesn't have a whole lot to say because he doesn't know anything about this particular subject. I'm assuming someone must have written his script or something. He must be reading from a teleprompter because he doesn't have any personal knowledge on this particular subject.
The one thing that matters for practicing law is passing the bar exam. But this is a problem. And the problem is diversity, equity, and inclusion.
Actually, there are three issues when it comes to state law licensing schemes. The first issue is that state bar exams were created with discriminatory intent. The intent was to exclude Blacks, Jews, and immigrants. They were created for this specific purpose. Discriminatory intent is very difficult to prove. This information has been available at least since the 1930s, when the American Bar Association lobbied from state to state for state law licensing statutes to keep out Jews, immigrants, and Blacks from the practice of law. There's statements from Harvard Law School, from the American Bar Association, which expresses their discriminatory intent. And then the second issue is that bar exams themselves were never valid measurements of the skills used in the practice of law, right? In order for a standardized test to have any merit, it has to actually measure the skills that are used in that particular profession based on psychometrics. They're supposed to interview practicing attorneys, and then they're supposed to determine what skills are used in the practice of law, and then the exam is supposed to be reflective of the actual skills used in practice. But that has never happened. They just made the bar exam unduly difficult to pass, bearing no relation to the actual skills used in the practice of law. And then the third issue is that it had a disparate impact, right? Clearly Blacks, Hispanics, and immigrants failed the bar exam at a disparate rate. I would say that this is the least compelling argument. I think that the most compelling argument is the fact that the bar exam didn't actually measure competency to practice law. The second most compelling argument would be the fact that it was created with discriminatory intent. And then the least most compelling argument would be the disparate impact. And for whatever reason, the task force which reviewed this issue decided to really focus solely on disparate impact, right? The fact that it was creating a barrier to entry for people of color. I think you could have gotten the same result without even addressing that. This addressed the fact that the bar exam does not measure the skills used in the practice of law, and I'm going to be addressing that shortly.
According to Washington State, there is insufficient equity brought about by the bar exam. And so, in a pair of orders on Friday, the Supreme Court of Washington approved, quote, alternative pathways to lawyer licensure.
I don't understand why he's complaining. I thought Republicans were supposed to be the party of states' rights. Whatever happened to states being laboratories of democracy, deciding for themselves what is in the best interest of their people? He doesn't even live in Washington, so how does this issue affect him? Now I'm going to play a clip from the Washington Task Force which reviewed this issue.
A little about both.
By the way, this guy was having audio problems, so some of it was unclear, but hopefully you will get the message. Like this pretty much summarizes what was in the report.
Both where the Bar Licensure Task Force is now, because I think these two conversations go hand in hand, and this will shorten my speaking later. So there's the good news for all of you. The Bar Licensure Task Force current proposal is not perfect, but it is a really, really good start. I have to speak of how much has gone into this. I have to speak about what has happened here. This has been more than 3 years of work by the most impressive group I have ever worked with. No offense to all of you. But the numbers bear it out. These are Supreme Court justices, law school deans, more Apex winners than I've ever had in a group before, all working together on this for over 3 years, doing research, traveling the country with their research.
So you hear that. This report was comprised by Supreme Court justices, law school deans, bar exam administrators. Like these are experts in this area. And this is what they decided. These were not just random people deciding to give a handout to blacks who were incompetent. No, they researched it. And I wish the report would have focused more on the fact that the bar exam does not measure competency to practice law instead of just focusing on diversity, equity, and inclusion.
Research, bringing in experts who have literally written the book on bar licensure to speak with, to discuss, to review our proposals. This is a lot of work that has come together in this. This proposal is very, very good. On both sides of it, this is very, very good. And it creates opportunities for us to continue improving it in the future. Our current system can best be analogized to the phrase security theater. It's security people put in place to make people feel safe, but it doesn't actually improve the safety of anything. And in so doing, by creating a false sense of security, it actually causes harm to people. It makes the situation worse. It makes it more dangerous. That's what our current bar licensure structure is. It is security theater.
Right. So the whole notion that occupational licenses actually protect the public, that is a misnomer. Occupational licenses only protect the current practitioners from competition. That it allows them to drive up the cost of their services by creating an artificial scarcity of services. And so when it comes to the practice of law, by keeping people of color out of the practice of law, what you're doing is depriving the public of access to legal services, right? This is the reason why the legal system is so unjust, because people don't have equal access to legal services. And basically the few attorneys who are licensed, right? I know people say that the legal profession is oversaturated, but it's actually artificially reduced, right? So the reason that the fees are so high is because of this artificial scarcity. So they don't have any access to legal representation, right? The few who are practicing, if their fees are so egregious that nobody can afford to pay for them. So the only reason that they're able to charge so much is because of this artificial scarcity.
Our current bar structure is not serving the public at all. It is failing the public because it is doing nothing to help them. And it is instituting racial segregation that was built into the bar exam to prevent people from having themselves serve better.
So it's not doing anything to help them. It's saying that you don't have the right to hire your counsel of choice, right? There's not a free market for legal services. You're relegated to hiring these people who are charging $500 an hour. If you want to hire someone like me who's not going to charge nearly as much, you can't do that, right? So you can't afford to pay the $500 an hour. You're basically this shit out of luck.
This new proposal serves the public better than we ever have, and better than anyone who's been working on this can think of a way to do. So if we care about ensuring the integrity of the legal profession, our current bar exam and its history kills the integrity of the legal profession, because we are what is undeniably a racist system that was designed for the purpose of being racist.
So this is what I talked about in that previous live stream when I talked about the history of it. That article, the Maroon law graduate, right? This is well documented. They created the bar exam with discriminatory intent. And so when I bring this issue up, they're saying, well, that was back in the 1930s. That has nothing to do with today. No, the bar exam was created for that express purpose. So it is relevant. And then the other problem is that state licensing officials were trying to not assume responsibility for the racist history with the American Bar Association, right? They're saying, okay, that's the American Bar Association. We're the state bar association. But no, their policies were really dictated. Like the state law licensing, the state bar associations were getting their policies from the American Bar Association, or the Supreme Court, I should say. They were basically rubber stamping whatever the American Bar Association said. And so finally, states are moving away from the American Bar Association. They're not just rubber stamping whatever the American Bar Association says.
We are not currently ensuring the integrity of the legal profession. We are harming the integrity. This current proposal takes steps to remedy that, while also ensuring that we are actually trying to protect the public. And where can we say more about championing justice than by ending inequities in this profession that were done actively to harm people and have actively harmed people? We are creating opportunities for a better legal profession, more representative of the members who need it.
Again, he was having audio problems, but this was a very long discussion, and I tried to edit the part which summarizes the report.
Yes. That is championing be rescinded, because what that prior resolution did was, in essence, disqualify the Board of Governors from ever having valuable opinions on this, unfortunately. What it did is, when the Board of Governors passed this prior resolution, it said, we, the Board of Governors, have biases that we are unwilling to question. Any research, and even though you are beginning a 3-year task,
Okay, so the biases that they have or had was that the bar exam was a valid measurement of skills used in the practice of law, and that because that was the status quo, it needed to be maintained. It was a history. Basically, this is a hazing ritual that attorneys had to go through, and they were reluctant to change, right? And so current practitioners don't really want to change, right? Because it doesn't benefit them. The only time it's going to benefit them is when they want to become licensed in another state. A lot of attorneys are complaining about the fact that there isn't reciprocity and they have to go through this process all over again. But wait, you want to keep people out of your state, so why can't other people keep you out of their state? The same thing. Like, the laws are different in every state, right? So if you're saying that the bar exam does measure competency, then you should have to go through this bar exam all over again, just like everybody else, despite the fact that you have 20 years of experience.
We want to impose our biases, our ignorant biases, on the on this bar licensure task force. In so doing, the Board of Governors made itself kind of or helpful or constructive. This prior resolution was designed behind a veil of ignorance, and it remains there. We now have more information. We now have 3 years worth of research covering decades worth of bar licensure.
I mean, they're acting like this is new information. This is not new information. This information has been around for a very long time. And when I filed my lawsuit, I presented it, and I think they disregarded it, mainly because it wasn't specific to my state. There isn't any data, right, that is specific. A lot of this data comes from California, New York. When it comes to psychometrics, right, standardized tests are supposed to have content validity and criterion reliability. They would not accept the data that I got from the California bar exam, but there was no data on the Texas bar exam. So this is very expensive to get this data, right? To get these psychometric experts to actually interview practicing attorneys and then try to tailor the bar exam to the actual skills. But no one ever did that. They just assumed that the bar exam was valid just because it was a long-standing tradition. This is just the way things were. It was unduly difficult, and nobody had any desire to change it except during COVID, because they basically were forced to change the licensing requirements, and then they had to re-examine this whole issue. I think if it wasn't for COVID, we would still be stuck in the Stone Ages.
For those who wish to speak and maintain this resolution that says that the WSBA discourages diploma privilege, that says that we need to maintain a bar exam, I would ask one question for you to think about before you say that we need to maintain a bar exam. What does that bar exam look like? If you don't have an answer, then the feedback isn't really constructive. If you do have an answer, I'm happy to answer questions on this, but I strongly suspect, and I can almost guarantee, the Bar Licensure Task Force has considered that. They have looked at data, and we have found that it is not useful.
All right, so now I'm going to play a video from Greta Van Susteren.
Greta Van Susteren. I'm a lawyer. I have 2 law degrees. I'm a member of the Bar of the District of Columbia. I've practiced law for at least 12 years, trying all sorts of cases, going into appellate courts and arguing them. I've taught at Georgetown Law School as an adjunct professor. I've taught evidence, advanced criminal procedure, trial practice. I know what it means to be a lawyer. You are about to take the bar exam. That bar exam is such a scam. It has nothing to do with practicing law. It has nothing to do with whether you're smart. It is the most bizarre thing that you have to go to and take, and I realize this, but just think about it. Think about what you're about to do. I know you're all freaked out. You're all nervous. You're all scared. You're sweating it. You're not sleeping. You're taking practice exams. You've spent a fortune on courses. But think about this. Think about what happens in this exam. And think about how it has absolutely nothing to do with the practice of law. Never once in the practice of law was I ever asked to go into a closet, answer a question in a certain amount of time, refer to no resources, don't talk to anybody, and come out of the closet and answer the question. That's what the bar exam is. You all have been taking law school classes for the last 3 years. You've been tested every single semester on all these courses. You've had exams at the end of first year, the end of the second year, end of the third year. You are so examined out. And for the life of me, I can't believe that you have to take this silly exam, but you do. This is just a scam, has nothing to do with your intelligence, has nothing to do with your education, has nothing to do with whether or not you'll be a great lawyer. This is the most ridiculous scam.
Okay, the reason that I'm showing this clip is because people have the logical fallacy of ad hominem attacks and appeals to authority. So if I were to say it, they're not going to listen to me because I'm a black man who didn't pass the bar exam, right? So I don't have any credibility. Anything that I say is based on the fact that I'm bitter and because I'm just not smart enough. Now, here's a white woman, right? I think it would have more credibility if it was coming from a white man, but this is what we have to work with. You have uh, a white man who said it this a minute ago, and now we have her saying it. She said this. This is a video which is at least 10 years old. I believe it was made in like 2012, maybe. Yeah. So it's about 12 years old. And when I was presenting this information, nobody would take me seriously. But as soon as she said it, go back and look in the comment section. Everybody automatically defer to her because she is such a political figure. She's well known. She's respected. It doesn't matter who's saying it. The data is there, and the data shows that the bar exam does not measure competency to practice law. So now I'm going to go to another article. Make sure y'all can see it. With little evidence to support the current bar exam's claimed objective, it's time to seriously consider the various alternatives. The dreaded bar exam, the final hurdle in one's journey to becoming a licensed attorney in the United States, and the source of enormous stress and mental anguish for so many aspiring lawyers every year. Take, for example, Paula Coughlin, who contracted stress-induced hives all over her body due to the stress of studying for the bar exam. Coughlin developed a method to cope with her problem by holding a hairbrush in one hand and her notes in the other. She would alternate between using a brush to scratch the hives and answering a practice question. Assistant Dean of Students at Rutgers University Law School, Anthony Rothman, had a former student who developed stress-induced hemorrhoids while preparing to take the bar exam. Rothman recalled the student had to roll to one side to cope while taking an exam. Both Coughlin and Rothman students passed the bar exams. However, some bar takers are not as fortunate. Sam Goldstein is one such example. Goldstein, a graduate of Arizona Summit Law School, took the bar exam for the 8th time in July of 2018 and missed a passing score by only 13 points, although at that point he had spent 5 years trying to pass. Goldstein was determined not to give up. There was actually a white man, and I'm saying white because people are assuming that blacks are the only ones who failed the bar exam. There was a white man who failed the California bar exam about 23 times. There was a white woman who had to take a mortgage out on her home after failing like 8 times. And a lot of this has to do with finances. So once she took a second mortgage on her home, right? Because if you're working and you're financially strapped, you don't have the resources, that's going to cause a problem, right? You can't work while you're studying for the bar exam, and you need to have good quality study material. So she took a second mortgage out on her home, and then she finally passed because the issue was not that she wasn't competent. The issue was that she did not have the financial resources for success. Unfortunately, these experiences are not isolated. Rather, the bar exam is a cause of widespread physical and emotional stress for new law school graduates. Why must aspiring attorneys in the United States go through this hardship after enduring 3 strenuous years of law school? Is the bar exam a necessary evil to ensure minimal competency in American lawyers and to protect the legal profession? Actually, when I litigated my case, that was one of the questions I had in discovery. Is the bar exam based on minimal competency, or is it some higher standard of competency? They didn't answer the question. They didn't feel that they had to answer the question because these people are pretty much untouchable. The bar exam is administered through the Supreme Court, and as we know, the Supreme Court is first among equals. We have the doctrine of judicial supremacy. So the legislature is not going to put any checks on the Supreme Court. The Supreme Court has, state Supreme Court, I should specify, has inherent authority to regulate the practice of law. So they create rules out of thin air, and then nobody challenges them. And so if they decide to, first of all, the law license is the only license in America which comes from the judiciary as opposed to the legislature. So let's start with that. Why is this one license not coming from the legislature? It's a classic case of the fox guarding the hen house. The legal profession is self-governed. Minimum competence and protecting the profession are the objectives that supporters of the bar exam say it accomplishes. However, there is little to no credible evidence that support these claims. In fact, overwhelming evidence shows that the bar exam fails to meet these objectives. First, supporters of the bar exam have failed to provide a reasonable definition of minimum competency, thus claiming that the bar exam attains this is a baseless assertion. Second, the bar exam only tests a narrow range of skills and cannot purport to ensure minimum competence when it overlooks so many important aspects of competent lawyering. Third, the bar exam is unnecessarily broad and forces hopeful attorneys to spend innumerable hours studying subjects they will never use in practice. Fourth, it fails to take into account and incorporate current competency issues afflicting the legal profession, which only bolsters these underlying issues. Lastly, the bar exam perpetuates prejudice against minorities attempting to enter the legal profession and consequently works against establishing equal opportunity and diversity in the profession. So the least compelling argument is diversity, but the more compelling issue is the fact that the bar exam did not measure competency. Now, when I took the bar exam, there were probably 50 subjects on the bar exam, and it was over a 3-day period. Now they have significantly reduced the number of subjects that are tested on the bar exam, and it's only a 2-day period, right? I would imagine I wouldn't have any difficulty passing the bar exam now, but when I looked at it, what was tested, I was like, okay, that seems more manageable. But trying to cram in 50 subjects over 3 days, and I have to take work, and then I have to stay at a hotel, and yeah, it was extremely stressful. Part 1 of this essay details the history and development of the bar exam in the United States. Part 2 outlines the problems with the current bar exam and how it fails to achieve its purported purpose. Part 3 suggests alternatives to the bar exam as is currently administered that would better achieve the bar exam intended purposes. Evolution of the bar exam. Okay, I kind of explained that in one of my recent live streams, but people assume that law licenses and bar exams have existed since time immemorial. It's not true. This is a complete social construct. If it was constructed, that means that it can be changed. This is not something that exists in nature. It's not something that is set in stone. I don't know why people are so resistant to change. Prior to the 1800s, forthcoming lawyers entered the profession through apprenticeships, clerkships, and oral examination. The first ever bar exam was an oral examination administered in Delaware in 1763. It wasn't until 1855 in Massachusetts that the first written bar exam was administered. However, in the 1870s, states developed the concept of diploma privilege, which allowed attorneys to practice after graduating from law school with no requirement to take the bar exam, right? So first, there were no statewide law licenses. They were admitted to a local bar exam based on a 10-minute oral examination. This is what Abraham Lincoln did. It wasn't until people of color, were being considered for practicing law that they decided to up the ante, and then they, decided to create law schools, because before that they were doing apprenticeships, and then they felt that the apprenticeships were pretty much limited to white men, wealthy white men, right? Because who else can afford to do an apprenticeship, or who had access to someone who would allow them to do that apprenticeship? So then they created law schools in order to make it more accessible to the public. Um, and once they had law school, the majority of the states had a diploma privilege, right? If you graduated from law school, you would automatically receive a law license. But then they felt that too many people of color were getting in, so they created a bar exam as a final screening method, and that was their intended purpose all along. I don't know, when I say this, people think this is a conspiracy theory. Like, when they went and researched this data, this is this has been available for a very long time. They just never wanted to consider it. Okay. Where was I? So the diploma privilege persisted until the 1920s, after which the American Bar Association began requiring written bar exams. Today, Wisconsin is the only remaining state to honor diploma privilege. Okay, so why are states giving deference to the American Bar Association? The American Bar Association is not a state institute. It's not a governmental institution. This is a private organization, and there's really no leadership, right? It's coming from the Supreme Court, but they're just basically rubber stamping whatever the American Bar Association says. Each state administers its own version of the bar exam that are typically very similar. Most state bar exams generally include a multi-bar examination, which is a 200 multiple choice question test that covers six substantive legal areas commonly learned learned in the first year of law school. The MBE is combined with the test taker's score in a multi-state essay examination. Additionally, some states require a multiple performance test, MPT, which is an examination meant to test fundamental lawyering skills with a realistic situation. Each of the aforementioned tests that together make up the bar exam are developed on a National Council of Bar Examiners, whose professed mission is to promote fairness, integrity, and best practices in admission to the legal profession. For many reasons, however, the bar exam in the present state runs contrary to the NCBE's stated objectives. So when we talk about diversity, equity, inclusion, this is their stated purpose: to promote fairness, integrity, and best practices. Deficiencies in a bar exam. The NCBE claims to strive for a competent, ethical, and diverse legal profession. Proponents of the bar exam, in accordance with the NCBE's vision, argue that it ensures minimal competency in a legal profession. However, there is little to no evidence that supports this conclusion. Neither the NCBE nor any state that administers the bar exam have provided a sound definition of what minimal competency entails. Without first providing a reasonable definition of minimal competency, one cannot legitimately claim that the bar exam achieves this purpose. This flawed reasoning, at the very least, calls for a reevaluation of the bar exam's purpose and a determination of whether it accomplishes that purpose. One need not endeavor too far away, however, to discover that the bar exam fails to produce minimally competent lawyers. The multiple sections that the bar exam is comprised of only test a narrow range of skills in slightly different ways. The exam is unrepresentative of the actual skills attorneys use in their practice. The legal profession does not usually involve the type of task one is required to understand to pass the MBE and MEE. Moreover, lawyers are not operating under the same time pressure. The exam essentially tests the test taker's ability to identify an issue and apply the appropriate law. Being a competent lawyer, however, demands so much more. Performing legal research, factual investigation, negotiation, counseling, and representing oral arguments are just some examples of skills that are fundamental for competent practice, but that are not adequately tested on the bar exam. Again, this is not new information. This was determined based on a task force from the ABA in 2009. They found that the bar exam was deficient, and yet the state Supreme Courts were slow to move. They did not see a desire to make any changes. A justification for not incorporating a broader array of skills on the bar exam that it would be impossible for a single exam to include them all. Rather, advocates claim that the bar exam includes the most important skills that ensure minimal competence and that it is the best method to screen against incompetence. However, this justification does not hold water because there are several other methods examined in part 3 of this essay that, if put into practice, would do a better job at attaining the desired objective. Apart from being under encompassing in terms of skill testing, the bar exam is overbroad in terms of subject matter testing. The exam unnecessarily compels test takers to study a wide range of general subjects, while in reality, most lawyers are specialists and only practice in a certain field of law. The MBE section of the bar exam usually incorporates constitutional law, contracts, criminal law, civil procedure, property torts, criminal procedure, and evidence. Moreover, the MEE section covers the aforementioned subject as well as business associations, conflicts of law, family law, trusts, and estates, and 2 subsections on the Uniform Commercial Code. Most of these subjects are taught in compulsory courses throughout law school. Therefore, individuals attempting to pass the bar exam are required to spend countless hours reviewing subjects that they have supposedly learned already and will likely never encounter in their careers. Forcing aspiring attorneys through this process is unreasonable and a highly inefficient way to ensure minimal competency, to say the least. Well, it's rote memorization, right? Because they cram this information, right? But then after they take the bar exam, they don't retain it. If you were to go to an attorney and ask them to take the bar exam on the spot, right, they wouldn't pass it. They would need to study all over again because it's not reflective of the skills used in practice. If it were based on minimal competency, any attorney should be able to take the bar exam on the spot and pass it. But no, they would have to engage in rote memorization all over again. They would have to go back to the drawing board, get some study materials, cram all this information in, and then they would forget it all over again. Okay, I just went. Furthermore, as a standardized test, the bar exam essentially examines a generic set of concepts and skills. Thus, it fails to screen for and incorporate what lawyers are actually struggling with in practice. For example, common reasons for malpractice claims includes preparation, filing, and transmittal of documents, failure to timely commence an action, investigation other than litigation, failure to communicate with clients, and lack of due diligence in working on a client's case, none of which are tested or measured on a current bar exam. A bar exam that purports to screen for minimal competence in attorneys should reasonably be expected to incorporate current issues of incompetence in the legal profession. Although these issues may change throughout the years, the law also changes, and a bar exam must account for these changes. Otherwise, it cannot genuinely claim to achieve minimal competence. The bar exam also has a history of prejudice against minorities. Although the exam is no longer explicitly discriminatory, it continues to have an unfavorable impact on underprivileged communities. That's not just blacks, that's people who are poor, that's immigrants, that it's those who have language barriers. Individuals that take the bar exam spend months preparing for it and upwards of 3,000 on prep courses and exam fees. Probably closer to 5,000, but that being 3,000 is extremely modest. Some individuals can afford to take a few months off of work to prepare for the exam, which gives them an advantage over underprivileged and typically non-white applicants that cannot afford to do so. The disparate impact of the bar exam on Black applicants is demonstrated by the results of the California's 2020 exam. Only 5% of Black first-time bar takers who graduated from the California ABA accredited law schools passed the bar exam compared to a 51.7% passage rate for white test takers. Nationwide statistics are similarly disheartening. Only 66% of black law students passed the bar exam in 2020 on their first attempt, while 88% of white first-time test takers succeeded. These somber statistics augment a recent study by Access Lex Institute that suggests the exam is a better test of resources than it is of competence. While the bar exam is certainly not the only reason for the prominent racial disparity in the legal profession, it does perpetuate it, which directly contradicts the NCBE's vision of a diverse legal profession.
In this press release. Okay. What does this mean? It means that the white people are doing pretty well on the bar exam and the black people are doing worse. It's true. Different groups have different outcomes and different things. That's true. That's true. So if you begin looking at the issue with the conclusion, we need more lawyers of XYZ race.
No, you need to begin the analysis of whether the bar exam is a valid measurement of competency to practice law, which it is not.
Then you're going to come to the conclusion that, oh, wow, this bar exam is not serving the purpose. The purpose of the bar exam is to get us the exact racial breakdown of lawyers that I want, and the bar exam is not doing that, so we got to get rid of the bar exam.
I think his lament is that the culture has moved away from what Michael Knowles represents, which is a theocratic patriarchy. He's just lamenting the fact that women, black people, gay people, trans people have gotten rights over the years, and that he's complaining that conservatives have not passed legislation to force these people to be second-class citizens again. That's what he's lamenting.
Yeah.
He is a theocrat, just like the rest of them at the Daily Wire. And he resents the fact that there is progress being made in terms of like emancipation for black people, women, gay people, trans people. That's what he resents. The fundamental, and I do mean fundamental, problem he has with our society is that he's no longer automatically, by the fact that he's a white guy, the top on the totem pole.
Or at least the requirement to take the bar exam. But is that really the purpose? Is that the purpose of the bar exam? Is that the purpose of law school and the legal profession? Is the purpose of the legal profession to make certain racial groups feel good about themselves, or even to generate income for certain racial groups? Is the purpose of the legal profession to have more lawyers?
The problem is that most people don't understand the role of an attorney. They think that attorneys are just capitalistic fodder. The reality is that attorneys are supposed to be stewards of democracy. According to Charles Hamilton Houston, a lawyer is either a social engineer or he is a parasite on society. So here's there's some case law, right? This is from the Supreme Court of Missouri. It says that this is basically referring to common law. It says that under common law, attorneys had the title of sergeants at law, and it says that they were virtual public officials. Here's another case law case from the Supreme Court of Texas. It says a lawyer actively participating in a trial is not merely a person and not even merely a lawyer. He is an intimate and trusted and essential part of the machinery of justice, an officer of the court in the most compelling sense. Because lawyers participating in litigation are key participants in the justice system, the state may demand some adherence to the precepts of the system regulating their speech. Attorneys are state actors, right, when they're engaged in litigation. It is a public office. It's not just, they're not private capitalists. I have one other case and I'm going to show you. And this is another case from Texas, Crane versus Smith. It says, attorneys as officers of the court. Okay. There's a public policy of securing to attorneys as officers of the court the utmost freedom in their efforts to secure justice for their clients. So attorneys are officers of the court. That is a public office, right? It's a judicial office. It's a judicial appointment. And they're essential to democracy, right? Okay, so this is a case that refers to absolute immunity when representing their clients. So there's a whole lot of case law showing that attorneys are state actors, that it is a public office. It's not, they're not private capitalists. Like, I don't know what you think the role of attorney is, that they're just here to make money. No, they're here, it should be diverse because it's supposed to be reflective of the community at large. So you need someone to advocate for the Black community. You need someone to advocate for the Latinos, etc. You need district attorneys. You need judges who are diverse. It should not be a monolith. It is a public office. Like, if you want to have a system which is exclusive, then you can do that privately, but you don't get to do that when it comes to a public position. The advent of the capitalist attorney started when Justice Brandeis blackmailed Woodrow Wilson into appointing him to be on U.S. Supreme Court. Justice Brandeis is the one who claimed that the amount of money an attorney charges should be commensurate with his skill and that the public should be grateful to pay it. In the 1890s, at the time when an average attorney was making $5,000 a year, Justice Brandeis was earning $50,000 a year. The courts are the one branch of government in which everyday citizens have direct contact with the state. It is the one branch of government in which everyday citizens have the ability to effect meaningful change. The legislature and the executive branches are both unresponsive to the will of the people. If the system of white supremacy is to be dismantled, it's going to happen through the courts. Real white supremacists know this, which is why they are still doing everything in their power to keep people of color out of the practice of law. Under the First Amendment, we have a right to petition the courts for a redress of grievances. The right to petition applies to all three branches of government, including the courts. When someone prosecutes a lawsuit, they are engaging in core political speech. By limiting the ability of one to petition the courts to those who are licensed by the state is effectively imposing a prior restraint on core political speech. Attorneys are not private actors. In addition to being officers of the court, the role of an attorney is a public office. Attorneys set the judicial machinery in motion.
Or is the purpose of the legal profession to serve clients, to give people the opportunity to defend themselves in court, to give the state the opportunity to prosecute criminals, to exact justice? The liberals tell us we now are implementing a policy according to which less qualified people are going to get these jobs. And the reason,
I don't know why we're assuming that they're less qualified just because of a bar exam, which has never been proven to measure competency. And on the issue of liberalism, according to Ayn Rand, conservatives are far worse than liberals. Although Ayn Rand disagreed with liberals, she said that they were at least on the side of progress, whereas conservatives maintained the status quo. for the sake of maintaining the status quo. She said that conservatives were anti-intellectual and that they stood in the way of progress. Here is a direct quote. Today's conservatives are futile, impotent, and culturally dead. They have nothing to offer and can achieve nothing. They can only help to destroy intellectual standards, to disintegrate thought, to discredit capitalism, and to accelerate the country's uncontested collapse into despair and dictatorship.
And we know they're less qualified is because the companies are saying, we are going to hire not based on merit. We are going to prioritize something, be it race or sex or sexual behaviors or I don't know, whatever, the cut of your jib, over merit. But the moment that you prioritize something over merit in a profession that is supposed to serve me, the customer, well, I get a little bit worried. If
The only valid meritocracy is the free market, right? So you as a customer should be free to decide who you want to hire, and everyone else should have the same right. When you're creating a barrier to entry, that is not a meritocracy. That is giving economic privileges to a certain group. There seems to be an assumption that those who fail the bar exam can just go do something else. It's simply not true. Those who fail the bar exam fare far worse than those who only have an undergraduate education. Having a JD without a license is like having scarlet letters. No one will hire you or help you because they see you as being inherently superior to them, despite being in a far worse position. Despite being highly educated, I am relegated to low-skilled labor. In these environments, I don't fit in. I am often told that I talk white. It's not that I talk white, the issue is that I am highly educated and I don't belong there. I am extremely difficult to manage because of my knowledge of the law. When employers screw me over, they know they're going to get sued. That's why they don't want to hire me. My inability to obtain a law license has absolutely destroyed my life and brought me to complete financial ruin. The power to license is the power to destroy. What are we supposed to do with the rest of our lives? Do you think that those who fail the bar exams deserve to die? I agree with the notion of pulling yourself up by your bootstraps. However, it's hard to do that when the government has its foot on your neck. The state should not be in the business of choosing winners and losers, nor should the state be in the business of preventing human beings from self-actualizing. If you want blacks to stop whining about racism, leaving things to the free market is the solution.
you are a client in Washington State, as a result of this ruling, you are going to be less likely to hire a black lawyer. You just are. Clarence Thomas wrote about this.
Not true at all. I'm not licensed, and there are people constantly asking me to help them with their legal problems. They don't care about the fact that I don't have a license. They want my help because they trust me and they believe that I am competent to represent them. They don't trust the attorneys that you are saying that they should hire. They can't afford to hire those attorneys, and they would prefer to hire me. And they don't have the option of doing that. We don't have a free market for legal services. They are relegated to hiring the $500 an hour white men that you're saying they should have to hire. And who's paying for that?
Many years ago. And he wrote about this because Clarence Thomas, one of the great jurists and legal minds in our country, one of the great public figures, actually, a graduate of Yale Law School, the best law school in the country, but he had trouble getting a job after law school. And he writes about this in his memoir. He says, the reason I had a tough time getting a job is not because I didn't have good grades. It's not because I didn't go to a good law school. It's because I am black and people assumed I was just an affirmative action case. If you have a policy that says, hey, we're going to give unqualified black people access to this institution. If you have a policy that says we're going to give qualified black people.
This is so ridiculous. He keeps saying that they're unqualified just because they didn't pass the bar exam, despite the fact that they went through 3 years of law school, the fact that they took the LSAT, the fact that they took all of these exams during 3 years of study. they didn't pass the bar exam. So what? Does that mean that they don't know what they're doing?
Where else in the whole planet world, on the planet Earth, if you've got a 4-year college degree, you're guaranteed to be at least middle class. But in America, you're not. So in other words, you just got chumped off, because the bottom line is if you had $125,000 a year income, which is commensurate with this education you supposedly have, you'd be all right. But they're telling you you don't. So you ain't doing what you're supposed to be doing, or you can't. And it's like going to law school. 75% of the people that graduate from law school do not practice law because there's no employment available. And most of them aren't making what they need to even pay off their loans for going to law school. As a consequence, we have a surplus of lawyers.
There's not a surplus. It's an artificial scarcity of lawyers. And here's my issue on this. If the government didn't interfere with the free market by criminalizing the unauthorized practice of law and imposing educational requirements in order to obtain a law license in the first place, none of us would have taken out those student loans. We took out those student loans in contemplation of being able to repay them by practicing law. Now the government is preventing us from repaying our student loans by not allowing us to earn a livelihood in our chosen trade. This was a fraudulent inducement, and this is why I support canceling student loan debt despite being an anarchist. The government created the problem, and the government should fix it.
Who charge exorbitant fees because they don't have the volume to keep the doors open. So they're charging high fees for little work. You have a situation with that, and that's a good example of what's going on. Like, would you go to a doctor's office if somebody referred you to a doctor and you found out that this doctor had never done an internship and never done a residency at a hospital, so everything he got.
Oh, here's the problem though. When I had this discussion with Judge Joe Brown, this was my argument, right? I was saying that the bar exam does not measure competency and that there should be alternatives for licensure. And I never got a chance to even present to him the alternative of apprenticeships, because that is what was done before the bar exam, right? He was the one saying that the bar exam does measure competency and you should have to take it. Now he's saying the complete opposite. Now he's saying that there should be an alternative, right? Or maybe he's saying there should be both. Maybe he's saying they should have to take the bar exam and do an apprenticeship. No, it should be either or. And if the bar exam does measure competency, right, then why is he sitting here advocating for apprenticeships? At the end of the day, unless you have experience in the practice of law, you're not going to know what you're doing. I have coached attorneys who passed the bar exam, but they didn't know what they were doing because it does not measure fundamental lawyering skills. And I have more litigation experience than many attorneys.
I was straight out of the books. Well, that's what's happening in law right now. You have people who are known as prominent civil rights lawyers, and they've never tried a jury trial in their entire careers. You got people like me who tried thousands of cases as a lawyer, let alone as a judge. And then you've got senior members of firms, white and black, who had 5 cases they've tried in 25 years. Hell, you're still a rookie. We had a DA in Memphis, and I was on the bench. 2.5 hours late for his swearing in. You know why? He'd never been to the Criminal Justice Center and had no idea where it is. So he's a DA. We had one person, a woman, who put her husband through law school. He graduated. He supported her. She went to law school, she graduated, took the bar, got sworn in. 4 days after she was sworn into the bar, she was appointed a Superior Court judge, unlimited trial jurisdiction, so the biggest rookie in the whole damn court was the judge, who had never set foot in the courtroom until she was sworn in as the judge. Less than a year and a half, wait a minute, out of law school, she got made a federal judge, and it's not because she was a great scholar, it was just political. So now you got a judge over a federal court that can declare acts of Congress unconstitutional, stay actions of presidents, and they're 18 months out of law school and never practiced law.
It sounds to me that he's saying that the bar exam does not measure competency to practice law. It sounds to me that he's saying that they should have some experience, i.e., they should take an apprenticeship.
Access to this institution, then that's great. No one would have batted an eyelash about hiring Clarence Thomas. If the policy at the airlines was, we're not going to prohibit female pilots, we're going to hire the best person for the job, maybe it's a female, then Professor Jacob wouldn't have made his vile, misogynistic comment to me on the airplane. But that's not the way it is. So just the practical conclusion of this is, if you've got your life on the line, whether we're talking literally on an airplane or we're talking legally, someone could throw you in prison for the rest of your life.
An airplane is not the same as the legal system. The legal system is a complete social construct. The legal system is created to be unduly complicated with these legalese and secret codes, which don't have to exist. The law could be written in plain English. So the fact that they decided to make the legal system complicated was a choice. The bar exam is opinion-based. There is no science being tested on the bar exam. The bar exam merely tests legal opinions.
You're going to be more likely in Washington now to hire a straight white male.
They can't afford to hire a straight white male, and the straight white male is not going to represent their interests, right? That's the reason why they want me to represent them, because they probably can't even find someone to take their damn case.
Or whatever, or an Asian guy or something. Whatever group historically does best on the bar exam, you're going to hire that group, because you're going to assume that everyone else is just there as an affirmative action case.
Clearly, he does not believe this is true, because if he did believe this was true, then he would leave it to the free market. But no, he does not believe in trusting the free market, right? He doesn't want the client to have the choice to decide who they want to hire, right? He's going to use the power of the state, so they're forced to hire the straight white male and pay the straight white male $500 an hour.